I wanted to talk about the use of bill signing messages by the governors here in the state of California. So, what's a signing message and why do governors even use them? You may recall that in Article 4, Section 10A, it requires that each bill that is passed by the legislature shall be presented to the governor. And then, of course, the governor has three options. If the governor signs the bill, then it becomes a statute. If the governor chooses to veto the bill, then the governor returns the unsigned bill along with the objections to the bill, which is the explanation of the governor's veto to the House of Origin. And then the third, of course, in California is the so called pocket signature rule, which says that if the governor fails to act within the statutory period of time, or the constitutional period of time, actually, then it becomes law without the governor's signature. Now, despite no constitutional provision allowing signing messages, or for that matter, there's no constitutional provision prohibiting signing messages, many California governors have used signing messages to accompany a governor's signature on a bill, just as US presidents have long used signing messages as well. So, what I wanted to do is explain the use of these gubernatorial signing messages, how they're used by the governor and also by the judiciary in their efforts to ascertain legislative intent or how to interpret a statute. So there are some examples of signing messages, of course. For example, in the 2022 California legislative session, Governor Newsom provided one to the members of the California State Senate. I am signing Senate Bill 851, which makes technical changes that will allow taxpayers paying the elective pass-through entity tax to fully utilize their other state tax credit. These changes are clarifying of actions made this year through SB 113, Chapter 3, a budget trailer bill. Although this modification may result in a revenue reduction, I'm signing this bill to clarify implementation so the Franchise Tax Board can execute the program in a manner that is consistent with previous legislative action. Maintaining structural balance and resiliency of the state budget is an ongoing challenge. In the future, bills with a significant fiscal impact and particularly tax law changes should be considered and accounted for as part of the annual budget process. Sincerely, Gavin Newsom. Now, while the governor doesn't have to provide a signing message for any measure that the governor signs into law, sometimes these messages play a valuable role. They might explain why the governor chose to sign a bill, perhaps to request additional law changes be made by the legislature, or to explain why a bill was not vetoed, like the message I just read to you. There are obviously numerous other examples. On average, Governor Newsom has done about 14 a year. So did his most recent predecessor, Governor Brown, about 14 a year. Governor Wilson did about 15 a year. Governor Gray Davis was the anomaly. He did about 82 on average per year, quite a high number. Now, as I said, these signing messages can provide helpful explanations or even direct executive branch administrative agencies on how a bill should be implemented or interpreted. These messages, can also provide guidance on any future legislative or budgetary action that may be required because of the bill's enactment. So, signing messages are definitely part of the legislative history. California courts have determined that gubernatorial signing messages are, in fact, part of a bill's legislative history. Now, that's despite the fact, of course, that they come after the legislature has already acted on a bill. So, for example, a state court of appeal characterized a gubernatorial signing message as, in fact, a legislative history. In the case of Wynn versus Wynn in 2008, California Court of Appeal decision, where they said there are two items in the legislative history that, in fact, support the trial court's interpretation. The first one cited was the bill analysis prepared by the Assembly Committee on Elections and Redistricting. Of course, we know that committee and floor analyses on pending legislation have long been used to determine legislative intent when there's ambiguity in a statute. The second item the appeals court ruled was Governor Arnold Schwarzenegger's signing message, and the appellate court actually cited part of the signing message in its decision. And they said in this particular case that the signing message is clearly a part of the bill's legislative history. I also wanted to go through a number of examples. I researched a number of cases, read through about 24 or so, and clearly, as they did in this instance, in Wynn versus Wynn, California courts can and do rely on these signing messages. So I found more than 24 appellate court decisions, including several recent ones in which state and even federal courts in California have relied upon these gubernatorial signing messages to help determine legislative intent and how to interpret a statute. So these are some of the cases that one could cite, or where the courts have cited approvingly the use of signing messages by California governors. In Arraias versus Cardulius, a Court of Appeal decision in 2012, the court noted that the legislature had amended a code section to overrule a particular case and restore the law. And the appeals court cited the governor's signing message. And in fact, the court quoted the message in toto. They also wrote that the governor's written signing message indicated that the bill's provisions would apply to first contracts only. And so they noted specifically the use of the signing message to determine what the purpose of the bill was to do. Another comes from the California Supreme Court decision in 2017 called Jerawan Farming Inc. versus the Ag Labor Relations Board. And there, the Cal Supreme Court cited legislative findings and declarations that were described in the bill analysis. And the High Court also said, see the governor's signing message on Assembly Bill 2596 and Senate Bill 1156. The court stated that the governor's written memoranda issued upon signature of a bill is admissible on the issue of the legislature's intent. And the Court of Appeal in 1998, in a case called In Re Carr, said of further relevance in terms of the legislature's intent was Governor Wilson's letter when he signed Assembly Bill 2716. They went on to say a governor's written memoranda issued upon signature is admissible, citing several cases, including People versus Ledesma, a Cal Supreme Court decision, People versus Tanner, a Supreme Court decision in 1979, a 72 Cal Supreme Court decision in Legislature versus Reineke. So there are a number of cases, even dating back to Lukens versus Nye in 1909, a Cal Supreme Court, citing the governor's role in participating in the legislative process when considering bills and signing them. The case or the decision in the In Re Carr court said, in the present case, Governor Pete Wilson wrote the legislature explaining why he was signing Assembly Bill 2716. And then they wrote about it, and they said that in essence, they were relying upon the signing message. The court said Governor Wilson's signature message explicitly stated that state prisoners were to be subject to the 15% limitation on pre-sentence section 4019 conduct credits. Additionally, the federal courts have even used California governor signing messages in the Association versus Becerra case in 2017. A federal appeals court said then Governor Arnold Schwarzenegger echoed this sentiment in his signing statement and cited the signing message of Governor Schwarzenegger for Senate Bill 1520. In a footnote, the court in Luares versus BAC Home Loan Servicing, a Court of Appeal decision in California in 2013 said that the governor had approved legislation known as the California Homeowner Bill of Rights. They cited Governor Brown's signing message on Assembly Bill 278. And in the case of Kim versus Workers' Comp Appeals Board, California Court of Appeal 1999, they said in his message confirming signature of the legislation, the governor asserted that excessive workers' compensation expenses had cost California 60,000 jobs per year. And they cited to the governor's signature message. Signing messages have also been relied upon in the budget context. For example, in St. John's Well Child and Family Center versus Schwarzenegger, a California Supreme Court decision in 2010, they talked about the governor's use of a signing message that also included some modifications to the budget appropriations, but they said the governor's signing message explained that his cuts to the spending bill were for the most part designed to increase the reserve and to reduce the state's structural deficit, and cited the governor's July 28th message on Assembly Bill 4X1. In another California appeals court case, Pearl versus the Worker Comp Appeals Board in 2000, the court said the governor's signature message to the California Assembly contained the following language, and cited to Governor Wilson's letter to the members of the Assembly, July 16th, 1993. In Alameda County Deputy Sheriff's Association versus Alameda County Employees Retirement Association, Cal Court of Appeal in 2018, the court said, according to the governor's signing message, the legislation was enacted to allow Los Angeles County to curb pension abuse. And they cited the governor's signing message on Assembly Bill 1659, dated September 7th, 1993. Similarly, in People versus Garcia, a 1998 state Supreme Court decision, they said the governor's lengthy signature message provides in part, and then they cited to it in Sonoma State University versus the Workers' Compensation Appeals Board, Court of Appeal in 2006, they said this amendment was apparently intended to further combat fraudulent psychiatric claims. In recognition of this intent, the governor's signature message to the California Assembly contained the following language, and cited to the governor's signing message. In Sakotas versus the Workers' Compensation Appeals Board in 2000, a state appellate court said, as indicated, the legislature enacted Section 3208.3 to combat the proliferation of fraudulent claims. In recognition, the governor's signature message to the California Assembly contained the following language. This package of reform saves money by tightening the standard for stress claims in the system. In another criminal case, the State Court of Appeals in 2002 said when the bill was signed on September 29th, 1993, Governor Pete Wilson's signature message heralded the fact that this amendment adds intentional drive-by killing to the first-degree murder statute. In People versus Ledesma in 1997, the state high court, our California Supreme Court, said, further bolstering our conclusion, the legislature in 1993 added to Section 12022.5 murder perpetrated by means of shooting a firearm from a motor vehicle. And they said in his signature message, Governor Wilson noted this bill imposes a sentence enhancement of up to 5 years for the use of the firearm. Additionally, in a footnote in the case, the appeals court said in signing this comprehensive legislative package, the governor made the following comments in his signature message to the legislature dated July 16th, 1993. The State Court of Appeal in the case of In Re Marriage of Wood, 1995 decision, the historical note to the statute cites Governor Wilson's signature message in which he stated, this bill would eliminate the income of a subsequent spouse or non-marital partner when when determining or modifying child support. Finally, there have actually been a number of unpublished appellate court decisions using signing messages as well. Now, these decisions can't be cited in court, but they're nonetheless, in my mind, instructive of the use of gubernatorial signing messages. And of course, they're consistent with all the reported cases. For example, in Vanguard Medical Management Building Inc. versus Baker in 2017, a federal district court in California, the trial court said the governor included a signing message that also appears to address the procedural due process issue. A federal district court also provided other case citations in Ray Carr, People versus Ledesma, and the California Employment Stabilization Commission versus Payne from 1947. Similarly, a state court of appeal decision, Castillo versus Military Department in 2015, that unpublished decision said the governor's signing message explains the need for such protections for service members who are called into active service. They went on to say that the signing message states the bill will ensure that equal protection is provided to all California National Guard members and other reservists. Likewise, in another California Court of Appeal unpublished decision, Lewis versus County of Los Angeles in 2020, they said in a footnote when Section 63.1 was amended, then Governor Pete Wilson prepared a signing statement that reads in relevant part, and they went on to cite it. And they said this comes from the governor's signature message on Senate Bill 675, dated October 1, 1993. In another Court of Appeal decision unpublished 2018, District Council number 16, Northern California Health and Human Services versus the Northern California Health and Human Services Agency, the court said in a signing message for Assembly Bill 2907, Governor Gray Davis explained the bill would help level the playing field for healthcare providers during contract negotiations. So as you can see from all of these examples, both state and federal courts in California can and do in fact rely upon signing messages that occasionally accompany a governor's signature on bills. Again, they are not required, but they're also not prohibited, and they've been regularly used by governors in past.